Good afternoon, ladies and gentlemen. My name is Ninoslav Babic. I'm a senior administrative advisor at the Croatian Customs Directorate, and I have over 14 years of experience in IPR customs enforcement, including 4 years in the EUIPO on the strategic project related to the online training for law enforcement authorities. Having this experience, I'm really happy to have this opportunity to speak at this workshop. Let me say that all began with the foundation of the World Trade Organization at the 8th round of multilateral trade negotiations under the General Agreement on Tariffs and Trades, known as Uruguay round of trade negotiations, where WTO was founded and where the TRIPS was born. We all know that in the part 3 of TRIPS, the basis for enforcement of intellectual property rights was given, and Articles 51 to 60 provides for provisions related to border measures. Within the EU, we have now the fourth regulation, the Regulation 608 of 2013. This is the newest one. And we have two additional regulations that are actually bringing the form for application for action. The latest one, Regulation 2020-2035, is just providing the new changes after the Brexit. So what is the scope of this Regulation 608? First of all, I need to say that it completely tackles all mechanisms of the border measures set up in TRIPS agreement. So Regulation 608 is applicable where goods are or should have been subject to customs supervision or customs control, especially when declared for release for free circulation, meaning import, then export or re-export, when entering or leaving the customs territory of the Union, meaning even if the goods are smuggled, when placed under a suspensive procedure or in a free zone or free warehouse. And also, I need to stress that Regulation 608 of 2013 is applicable to all valid intellectual property rights in the EU. There are some exceptions, of course, because customs administrations always struggle with resources. So there are some situations where we cannot use the Regulation 608. Most of them for reasons of being effective and assigning our resources properly. So first of all, first exception is that goods, after the goods are released for free circulation, even under the end user regime, we cannot initiate the procedure according to 608. Then all non-commercial goods contained in traveler's personal luggage, meaning if we can consider the goods in personal luggage are for further resale, we can initiate the procedure. If not, then we need to leave the goods with the traveler. And then we also do not tackle parallel trade and overruns, and we are aware of the fact that parallel trade is a form of infringing the rights of the producer and the rights holder, but we consider these goods as original, and for that reason, we do not waste our resources for stopping or tackling parallel trade. Also, overruns. If the rights holder agreed with the producer, the company that will produce for him a certain amount of products, if this company decides to produce more for their own profit, we need to consider these goods as goods as originals, and we cannot tackle these products, especially because the rights holder can solve this problem with his partner, with their partner, using different legal mechanisms. So what is the customs service role according to the regulation 608? We have the interceding role. We do not have arbitrary role. That means that customs role is to suspect that there is an infringement. We do not need to establish this infringement. Of course, we will run the procedure. We will keep the goods under the customs control until the procedure is over. And then if through this procedure is proven that the goods are infringing the intellectual property rights, then the goods will be removed from the customs system and then destroyed. We will not permit the entering of these goods on the market. This procedure that we run according to the regulation 608 enables the rights holder to inspect the goods and take samples, to confirm if the goods infringe his IP rights, to request the destruction of the goods, or initiate the court proceeding. So what is actually this suspicion, the basis of our work? This suspicion is based on two questions. First question is, are the goods related to any valid intellectual property right? And this question has a lot of sub-questions. As many IP rights we have, that many questions or sub-questions we have. We need to check when we inspect the goods during this physical control. We need to see if the goods are marked with the mark identical or similar to a registered trademark, or is the geographical indication used on the product, or is the product produced based on the unregistered or registered design. Then is the product related to any copyright or related right based on patent, related to the denomination of plant variety, and so on. And then if the answer on this first question or these sub-questions is yes, then we have another question. Are the goods produced by the rights holder or with his consent? And in this question is suspicion-based. If we are not certain that the answer on the second question is yes, then we need to initiate the procedure. So before the formal initiation of the procedure and sending notifications to parties, we need to do the physical control of the goods. We need to take some samples and take some photos that we will prepare to send to both parties, but especially to the rights holder, because he can sometimes, based on the photos, conclude that this is actually an infringement of his rights. Of course, we need to identify the intellectual property right concerned. We need to conclude if there is an application for action covering this intellectual property right. We need to identify who is the rights holder. And then we need to decide what type of the procedure we will run related to these products. So what types of procedures we have? First of all, the most common, most used procedure is standard procedure, of course. This is procedure based on the application for action. This application for action is not more than a express of willing to cooperate with customs, sharing information, and asking a request to customs to protect or to enforce certain intellectual property rights. I will speak a bit later, a bit more about application for action. The second type of procedure is procedure for perishable goods. Everything is the same as in standard procedure, except the deadlines. For standard procedure, we have the deadline of 10 working days. For perishable goods, we have 3 working days. And when we are speaking about perishable goods, we need to say that we consider to be a perishable goods goods that can deteriorate in 20 days from the day when the goods are stopped. Then we have the small consignment procedure. This is our way to tackle online purchases and all the traffic coming through postal hubs and express couriers. This procedure is also based on application for action, because in the application for action form there is an option that each applicant can decide. If they opt for small consignment procedure, then we will tackle all these cases in a different manner, and I will speak a little bit more later about that as well. Then we have ex-officio procedure. This is also something that is set up in TRIPS agreement. So the customs authorities in the EU can act even if there is no valid application for action. And we need to consider this a little bit wider. So maybe the rights holder has application for action, but this intellectual property rights right that is being infringed with this product maybe is not included in his valid application for action. In this case, we also need to run the case ex officio. Now, let's see what types of applications for action we have. First of all, we call it NAFA. National application for action is when the rights holder requests application in one member state. So that means from the perspective of Croatia, of Croatian customs, the rights holder needs to send this application for action to our department that is managing applications for action, and after granting, this application covers only Croatia. Union application for action can cover 2 or more EU member states, and needs to be filed in one of these 2 or any member state that needs to cover this member states and then some other member states. There is a data range because application for action, as I said, is expression of will to cooperate with customs and request to customs to enforce certain intellectual property rights. So first of all, the applicant, the rights holder, needs to provide his details, the contact points, his status, who will represent him for administrative and technical matters. In case of union application for action, he needs to provide contacts for all member states. He needs to provide information about his IPR portfolio that he wants to be included in this application for action. Of course, he does not need to put all his IP rights in this application. He may or may not. It's upon his decision. And he needs to provide information about either original products or infringing products. And this part is really important for us because information about original products and infringing products can help us when we have goods in front of us during the physical control, that we have a certain level of knowledge about original and potentially infringing products in order to help us base our suspicion and proceed with the case. And also, this application for action form is a good way to provide to us information about known infringers, meaning about companies involved either in producing, trafficking, or importing infringing products into our market in order to help us to set our risk management systems profiles and to easier detect shipments containing infringing products. So let's go a little bit deeper into each of these procedures, except a procedure for perishable goods, because it's the same as standard except the deadline. So first we send the notifications to both parties. On one side, we send notification to the contact person of the holder of the decision. This is the rights holder side. And then to one of three possible persons on the goods side, we can say. We can have declarant, we can have owner or holder of the goods, and we are not obliged to send this notification to every single one of them. We need to choose one of them and send notification to one of them. Usually this is the declarant. But this is actually the party, the person that it's we can reach very easy. Usually the one who is cooperating with us on this specific customs procedure. We will have photos. We can send photos to both parties. We can provide inspection of the products to both parties, and we can provide samples only to the rights holder, and he can take the samples as well to analyze them, but everything needs to be finalized within 10 working days. If we have confirmation of the infringement from the rights holder, we need to see what is the reaction of the opposite party. And if there is agreement that the goods can be destroyed, or deemed agreement of the declarant, owner or holder of the goods, then we can proceed and destroy the goods. However, if there is no agreement, or we cannot deem agreement of the declarant, owner or holder of the goods, then we will inform the rights holder about that, and then he has a possibility to initiate the court proceeding. If this still can be finished in 10 working days, meaning initiation of the court proceeding, we all know that court proceedings can take years to be finished, but he needs to initiate the court proceeding in the first 10 days, or he can ask for extension. This request for extension needs to be in first 10 days, and then we can provide 10 additional working days, and they are continuously counting after the first deadline. So that means 20 working days from the first notification to the rights holder. In small consignment procedure, first, let's see the definition or conditions for consignment to be considered small consignment. This is a consignment in postal or courier traffic, and it's maximum 3 articles or maximum 2 kilograms. If not, we need to run standard procedure for example, 4 goods in postal traffic, 4 products in one shipment in postal traffic. We need to consider this not small consignment, and we need to run standard procedure for that. So we cannot also run the small consignment procedure for all infringements of all IP rights. We can only do this for infringements of the trademark, design, copyright, and geographical indications. It is based on AFA because the applicant needs to mark this in the application form, and when granted, we can run this procedure, and this is not possible for perishable goods. So in small consignment, we will not send notifications to both parties. We will send notification only to the declarant, owner or holder of the goods, again, only to one of them. And then if there is agreement or deemed agreement for the destruction, we will destroy the goods without the participation of the rights holder. We will just send them the bill if this is regulated by the national regulation. There are some countries in the EU where customs destroy the goods and in small consignment and does not request the reimbursement from the rights holder. There are some member states where we still expect that the rights holder organize the destruction and pay for everything and so on. If there is no agreement, then we will notify the rights holder or the holder of the decision, and then he will have 10 working days from this notification either to negotiate with the declarant, to withdraw his opposition, or to initiate the court proceeding. I need to say that this first option, negotiation and agreement between two of them, is very often reached by the right holder. So we have a few court proceedings for the products in small consignment. Ex-officio procedure, meaning we have a suspicion that certain products are counterfeit, but we do not have this IPR infringed covered in the application for action. We will notify both parties, but we will expect from the rights holder to submit national application for action within 4 working days. If national application is submitted and granted, we will continue with the procedure under the terms of the standard procedure, meaning that the rights holder will have 10 working days in total from the first ex officio notification, 10 working days, so 6 days more to run through the procedure, to see the products, to, if he wants to analyze the products or initiate the court proceeding. Again, ex officio procedure is not possible for perishable goods. And what can be the result of this procedure? I can say that there are only 2 possible results. Either we are going to release the goods, or we are going to destroy the goods. Of course, there are some different conditions inside and different basis for this release or destruction. So we will release the goods if the goods are original, or if are not infringing, if the rights holder says these are not original goods, but these products are not infringing any of my rights. We will release the goods if there is no reaction of the rights holder. And of course, after the court proceeding, if the court decision is that there is no infringement, then we will release the goods again. And then we will destroy the goods if the rights holder confirms the infringement and there is agreement or deemed agreement of the declarant holder or the owner of the goods. And of course, after the court proceeding, if the court decision is that there was an infringement of the intellectual property rights. We have some tools, of course, that help us in our work. First of all, the most important database is COPIS. This is anti-counterfeiting and anti-piracy information system. This system is mandatory for all EU member states, so we all use it. Some of the member states are using this system through the system-to-system interface because they have they've developed their own IPR enforcement, customs enforcement systems before COPIS, so they needed to establish an interface to communicate with COPIS, or there are some member states that are using COPIS directly, using light client user interface. COPIS serves 3 different matters, tackles 3 different matters. It's used for application for action management, meaning that all application for action, national and union application for action, even expired applications for action, are visible to all member states, to all customs administrations of the member states, and all infringements needs to be registered. Intellectual property rights infringement cases needs to be registered in the system. Of course, we can extract statistics and create statistics reports based on information in COPIS, so we can check how many applications for action we have in total in certain countries and so on. And we can also see, we draw different types of statistics related to infringement cases. So we can see how many cases we had, how many articles of certain type or coming from certain countries, and so on and so on. Another useful tool for us is Common Customs Risk Management System. This system is used for exchange of risk information among member states and the Commission using risk information form. So this risk information form, one customs authority can send to another member state or to several member states or to all of them, including Commission and so on. And this risk information is immediately available to all customs risk management units in the EU member states, and they can prepare their own the risk profiles for their own national risk management systems. So they can use this information immediately to create profiles, and then since these national risk management systems are linked with the national customs clearance systems, uh, these risk profiles can help detecting suspicious shipments and help us detecting shipments containing intellectual property rights infringing products. Another tool, a very useful tool for us, is IP enforcement portal. This is a tool managed by EUIPO, and I know that my colleague Nicole Semyevsky will speak about this tool tomorrow. I just want to say how important this tool is for us, because this tool is designed to establish links between the rights holders and enforcement authorities. Currently, we have 1,000, at least it was the fact from yesterday, 1,000 companies, rights holders having the account on IP enforcement portal. And each rights holder can create, manage, and access only their area. They cannot access the areas of other rights holder, and they can put the company information and contacts, especially local contacts, IPR portfolio, products, and what is even more important, they can send alerts to enforcement authorities. On the other side, enforcement authorities can see all information, so all areas of all rights holders with all information there. They can notify the rights holders using the potential infringement or trend functionality of the database of the portal. And this is now used as a pilot uh, in certain member states, EU member states, as official notification for the purposes of running the procedure according to the Regulation 608. And authorities among themselves can also notify each other using the functionality interesting case, meaning if a certain member state customs authority have an interesting case with a new trend, with information that can be used in another member states, uh, they can send this information to others using interesting case functionality. What are the benefits of this IP enforcement portal? The benefits are that everything is automatically translated to all EU official languages. And so the local customs officers who usually do not speak foreign languages can see everything in their own language, because the whole database is based on drop-down menus, so they can search and scan everything in their language. And the contacts are also local, meaning that if our local customs officer needs to contact a representative of a certain brand, he can search for contacts there and contact him directly in real time, even if the seat of the rights holder is in on the other side of the world. I will not bother you a lot with statistics because I know that Nathan will follow with more statistics and information. I just have 2 slides where I want to stress importance and show that we are efficient in the EU, protecting EU market from IPR infringing articles. As you can see from this slide, the spread is over 9 last years, and in the last year we had 1.8 billion euros value of detained infringing articles. This is $2.14 billion US dollars, and we have over 40 million IPR infringing products detained. This is a huge quantity, and this is actually hard work behind this, hard work of the customs authorities of all EU member states together. The second slide with statistics is the slide information with the provenance countries for the products infringing IP rights in the EU. As you can see, 1/3 of the infringing products to the EU market is coming from China. Then almost a third from Pakistan. Then we have a third Moldova, Turkey. Okay, Bulgaria is an EU member state, so I don't know what is the basis behind this. Maybe they couldn't see what was the real provenance or origin of the product. And then we have Hong Kong with 4%. So we are focused on the South and East Asia, and we need cooperation with the countries in your region, and of course we hope for help through this cooperation. I can say that in the EU we have 2 customs action plans for cooperation in IPR enforcement. One is with China and one is with Hong Kong. So we have established the contacts with these 2 countries. We cooperate closely, we monitor the statistics, we share the data, and so on. So let's conclude. And as conclusions, I can say that we have a clear legislation, that we have efficient system that is focused on cooperation and exchange of information, and this cooperation and exchange of information is visible through between the national customs authority one to another, with the Commission, with the rights holder. We are especially focused on the training with the rights holder, where they can present us their knowledge, their tips and tricks for recognizing counterfeit products and so on. And I can say that this is very useful. And of course, we have established cooperation with other enforcement authorities. We also have some models of cooperation on the EU level under the EUIPO, under the Office for Anti-Fraud Office of the EU, OLAF, or Eurojust. There are all cooperation models that are very live in the EU and very useful for us. And of course, we have cooperation with some of the provenance countries. Of course, there is still an area for improvement. Of course, we are always monitor the implementation of our legislation to see where we can do more, if we need to slightly change certain mechanisms to be more efficient. There is an area of improvement in the exchange of information, especially for risk information. And of course, there is a lot of area for improvement in cooperation with the provenance countries. So That's all from me. You have here my contacts. If you wish to contact me and discuss this in any other way, feel free to contact me either on my email or my other contacts directly.